The broadcast is now starting. All attendees are in listen-only mode.
Okay, well, hello everyone. Good afternoon. I hope everyone can hear us with no problem. Welcome to one of our other webinars of the PlanIt program. My name is Raya and I will be facilitating the webinar today. This webinar is the last event of the PlanIt program in 2017, and it is the final one of the webinar series altogether. We hope that you have been able to enjoy the program so far, and you know that you can always access the previous events using the PlanIt page of the local planning handbook. If during the webinar you have any questions, please post them using the webinar control panel located on the right-hand side of your screen, and we will get to your questions at the end of the webinar. We also have two handouts attached to the webinar control panel. One is the Fair Housing Model Policy, and the other one is a guide that they will be referenced through the webinar, so they're there for your download at any time. Today's session is creating a local fair housing policy, and we will introduce the new model local fair housing policy and its content and explore how it can be used in your community. So now let me briefly introduce our presenters. Jonathan Stanley is a housing analyst at the McCouncil, and previously he served as a program and policy specialist at Minnesota Housing, working on numerous programs in its single and multifamily division. Leah Robertson is a staff attorney at Housing Justice Center, and prior to that, she was the supervising attorney of the Housing Discrimination Law Project at Mid-Minnesota Legal Aid. Leah focuses her work on enforcing fair housing laws on behalf of the low-income and advocating for fair housing policy throughout the region. And with that, I'm going to turn it to you, Jonathan, to start the presentation.
Thank you, Raya. So what will we be covering today? We'll start out with some background on the Federal Fair Housing Act, the Minnesota Human Rights Act, and provide some fair housing basics. We'll discuss the applicability of the Federal Fair Housing Act and what are known as protected classes under the acts. We'll talk about some common and some not so common potential impediments to fair housing. We'll describe why a community, whether or not it receives direct federal funding, would adopt a local fair housing policy and what the contents might look like. We'll provide a deeper dive on some of the key elements of an effective fair housing policy and provide some tips on crafting a policy that's a good fit for your locality. And finally, we'll highlight some resources available to help your municipality define or further your fair housing goals and objectives. The Federal Fair Housing Act was passed as part of the Civil Rights Act of 1968 and was signed into law just a week after the assassination of Dr. Martin Luther King, Jr. A primary purpose of the Fair Housing Act was to protect renters from landlord discrimination, but the larger goal of the Act and subsequent amendments in 1974 and 1988 is a housing market where everyone should have equal access to housing opportunities. The United States Department of Housing and Urban Development, or HUD, is the primary entity that oversees complaints and enforcement of the Fair Housing Act through its Office of Fair Housing and Equal Opportunity. As we'll describe in a bit, however, HUD's not the only party that oversees fair housing and to which a violation can be reported in the state of Minnesota. So who must abide by the law? The short answer is basically everyone. You can see here there's landlords, brokers, property sellers, contractors, condo and townhome associations, government entities. The Fair Housing Act applies virtually to everyone. Generally speaking, the Fair Housing Act makes it unlawful to take adverse action in housing because of protected class status, which we'll explain in a moment. There are three major categories of violations. There's disparate treatment, which occurs when a housing provider treats a member of a protected class differently from other persons. There's disparate impact, which is a facially neutral policy that can be found to have a disproportionate effect on a protected group. And there's failure to affirmatively further fair housing, which is when federal fund recipients do not meet their obligations to recognize impediments to fair housing and take steps to overcome these impediments. As mentioned, Disparate treatment is when a housing provider or other party treats a member of a protected class differently from other persons. This may take the form of refusing to rent to a member of a protected class, offering different terms and conditions based on a protected class, steering or when real estate brokers guide prospective homebuyers towards or away from certain neighborhoods based on their race, advertising that expresses preferences, discrimination, or a limitation based on protected class status, coercing, threatening, or intimidating individuals or other entities for enforcing fair housing rights, or a failure to allow for a reasonable accommodation for a person or household with a disabled household member. The disparate impact doctrine allows for a remedy when practice may be neutral on its face but has an unjustified adverse effect on members of a protected class. In other words, a disparate impact is unintentional, whereas disparate treatment is an intentional decision to treat people differently based on race or other protected characteristics. In 2015, there was a landmark court ruling when a Texas-based nonprofit alleged that the Texas Department of Housing and Community Affairs had caused continued segregated housing patterns by allocating too many housing tax credits for housing in predominantly black inner city areas and too few in predominantly white suburban neighborhoods. The Supreme Court found that the department failed to meet its burden to show that there were no less discriminatory alternatives for allocating the tax credits. This ruling opened the door for disparate impact claims under the FHA when policies are deemed to be artificial, arbitrary, or are considered to create unnecessary barriers that result in a disparate impact. This case helps illustrate the scope of fair housing law, which can go well beyond individual level transactions and can apply broadly to government and other entities. The third type, failure to affirmatively further fair housing, will be discussed later in the webinar. So what are these protected classes? This is the list as spelled out in the Fair Housing Act. It is unlawful under the Act to deny a rental or sale to someone based on their race or color, the religion they practice, their sex or gender, their familial status, in other words, whether or not they have children, their national origin or ethnicity, or their status as someone or relationship to a household member that suffers a disability, defined as a physical or mental impairment that substantially limits one or more major life activities. The Minnesota Human Rights Act is another guiding piece of legislation pertaining to fair housing. Like many states, there are additional protected classes identified in Minnesota statute. With only a few exemptions, it is further illegal to discriminate in the state of Minnesota against any person based on their creed or a strongly held belief, their marital status, their public assistance status, that is, whether or not a household receives public assistance, or their sexual or affectional orientation. Because some state and local laws provide greater protection than federal law, it is important to check both to see if rights have been violated and the law may provide a remedy. Besides those basic protections, the Act requires housing developers who receive more than $50,000 in state or local funds to affirmatively market housing opportunities to minorities and other protected groups. It further requires that landlords of rental housing that contains accessible units give priority for the rental of an accessible unit to a disabled person or a family with a disabled family member. And similar to federal requirements, the Act declares it unlawful to refuse to rent, sell, or lease real property because of a protected class status, to advertise in a manner discouraging members of protected classes from pursuing housing, or for a real estate broker or real estate salesperson to refuse to sell, rent, lease, or offer a unit to any person of a protected status based solely on that status. As shown, the Fair Housing Act and the Minnesota Human Rights Act have very broad applicability, covering near all rental and sales of housing, both public and private. The few exemptions that exist relate to certain religious-based housing and to owner-occupants of small multifamily properties. Now, in addition to the Fair Housing Act, local recipients of certain federal funds, such as Home Investment Partnership Program or Community Development Block Grant funds, have additional obligations, including to produce what is called an analysis of impediments, in essence an examination of how fair housing goals might be or are being impeded by local or regional factors in both the public and private sphere. Further, the findings of the analyses are meant to inform consolidated plans as required by HUD and help in what's called affirmatively furthering fair housing. We'll describe some more about how those efforts take shape in the region in a moment. A bit about how the fair housing complaint process works. Anyone can file an administrative complaint with HUD or the Minnesota Department of Human Rights at no cost. Complaints can be filed by an individual, by an entity such as a community group, or on behalf of individuals by advocacy organizations such as Minnesota Legal Aid here in the Twin Cities. For administrative complaints, that is, where the complainant submits a complaint to a government agency to investigate the adverse action, it must be filed within 1 year. In this process, the federal or state agency initially acts as a neutral fact finder. If an investigation is undertaken, the respondent is notified and the agency will interview both complainant and respondent and any other pertinent witnesses. During the investigation, there is opportunity to settle or conciliate the matter if both parties agree. If the agency finds reasonable cause that discrimination occurs, they stop being a neutral fact finder and instead become actively involved on behalf of the complainant. At this point, the agency often will attempt to settle the claim on behalf of its agency and the complainant. If no settlement occurs, the agency may proceed to civil litigation or a contested administrative hearing. If no cause is found, the complainant still has the ability to file the case in court so long as the statute of limitations has not run. It is useful to note that the statute of limitations, while available, is very short in the case of fair housing laws. As mentioned, administrative complaints must be filed within 1 year from the date of the last discriminatory incident, while court complaint claims under the Federal Fair Housing Act must be filed within 2 years of the adverse action, and under the Minnesota Human Rights Act, there is just 1 year to file a claim. It is important to note, though, that filing with an administrative agency tolls the respective jurisdiction's statute of limitations. That is, it allows for the pausing or delaying of the running of the time period in the statute, such that a lawsuit may potentially be filed after an agency decision has been made. As mentioned, recipients of federal funds such as home and CDBG are further required to take meaningful efforts to affirmatively further fair housing. HUD's final rule on affirmatively furthering fair housing has among its purposes to incorporate explicitly fair housing planning into existing planning processes, the Consolidated Plan, and the Public Housing Agency Plan, which in turn incorporate fair housing priorities and goals more effectively into housing and community development decision making. As you can see, HUD views the analysis of impediments and related consolidated and comprehensive planning exercises as having a positive and integrated impact, providing important inputs into much broader city functions such as housing and community development. While the affirmatively furthering fair housing final rule is relatively new, it will be interesting to see how effectively it helps communities in reaching their community development goals and objectives while lessening or reversing racial segregation or other forms of housing discrimination. In the region, a number of communities that receive federal funding requiring an analysis of impediments and a preparation of consolidated and annual action plans have banded together to produce a regional analysis of impediments to look for stronger ways to affirmatively further fair housing. This is in recognition that fair housing issues transcend municipal boundaries and that solutions to overcoming identified impediments require collaboration and innovation. The Fair Housing Implementation Council, often known as the FHEO, includes 15 city and county governments as well as the Metropolitan Council. The regional analysis of impediments takes a comprehensive look at fair housing issues in the region and includes analysis of items such as zoning codes, tax credit and public housing policies, areas of concentrated poverty, and gentrification and displacement, among a number of other items. So one key to tackling fair housing issues is for local governments to do a sort of self-scan of potential impediments to fair housing in their jurisdiction. This list isn't exhaustive, but we want to give a flavor of some potential impediments that aren't as obvious as, say, someone being denied a unit based on race or country of origin. Some not so obvious impediments just relating to disabilities, for example, that your community might want to take a look at might include resistance to development of housing for persons with disabilities due to NIMBYism or community pushback, insufficient curb cuts that limit the ability for disabled persons to live in housing of their choice, or a lack of housing accessible to persons with disabilities in general. Restrictions on modifying housing to serve those with disabilities or that make it difficult to find housing in certain neighborhoods could also be disability-related impediments. Other impediments that might exist at the local level include a dearth of large rental units that can accommodate larger families, such as those prevalent among certain immigrant groups, zoning that limits the use or size of group homes, large minimum lot or home sizes that make housing less economically feasible and therefore won't likely be built to serve a range of incomes, a geographic concentration of low and very low income persons, or a concentration of assisted housing in itself that limits residential opportunities for certain populations. A few other potential impediments might include a failure to provide fair housing related information in a variety of languages used in your municipality, and this is one of the policy recommendation items we'll discuss later. Restrictions on what constitutes a family for the purpose of occupancy standards, and restrictions on unique types of housing such as accessory dwellings, which could include adding units within or external to homes in the community, or on manufactured or mobile homes that can provide lower cost options and provide for a range of incomes. As you're defining your community division and drafting goals and policies, you might want to consider speaking towards these in your comprehensive plan update. Again, while not at all exhaustive, these types of issues are illustrative of areas where a community can assess and potentially take action to further fair housing. And now I'll hand it over to Lael to discuss why communities might adopt a fair housing policy and what that policy might look like.
Thank you, Jonathan. Good afternoon, everyone. So as Jonathan said, I'm going to now turn to talking about the fair housing policy, the model fair housing policy, and the accompanying guide, which has been provided to you by the Metropolitan Council. So the Metropolitan Council's model fair housing policy and the guide, which were created by the Housing Justice Center, were designed to meet a number of changing needs and practical considerations that really are already affecting and influencing city staff and decision makers. For example, our communities are changing. They continue to become more and more ethnically, racially, and economically diverse, with people of color, immigrant families, and people with disabilities becoming large portions of our communities. This increases the likelihood that fair housing issues will surface. Secondly, a fair housing policy can clarify the chain of command when fair housing complaints arise, identifying who is responsible for addressing those issues and referring them in a timely manner. A clear fair housing policy can also help staff be prepared to answer questions, allowing them to have confidence in how to react to fair housing issues and in where to find information and referral sources. And finally, the Metropolitan Council will soon be requiring that Livable Communities Act grant recipients adopt local fair housing policies, so it allows access to those community resources. And details of those requirements will be outlined in the 2018 Livable Communities Act Fund Distribution Plan. In other words, a fair housing policy allows a city to declare its commitment to fair housing, to ensure it is effectively serving its citizens, and really to plan proactively both to avoid fair housing issues and to take advantages of opportunities to increase housing choice throughout its jurisdiction. We've broken the key elements of a fair housing policy into two components. External components, which relate to the city interacting directly with its residents, conveying fair housing information and handling fair housing complaints, and internal components, how the city holds itself accountable to promote fair housing within its departments. Throughout this presentation, we'll also review some best practices for cities. And while these best practice elements aren't essential, they assist the city in demonstrating that fair housing is a city directive, not just a legal obligation. Key elements of the external components are complaint identification and a referral process, meaningful access to residents, for residents to fair housing information, and making sure that cities have additional required policies or encouraged, that are required or encouraged under civil rights laws. Key internal fair housing components include fair housing training for city staff, a process for project planning with a fair housing lens, a commitment to ongoing analysis of city procedures and policies with an eye toward fair housing implications, dedication to robust community engagement, and for those with or without federal funds, with or without the receipt of federal funds, a procedure to make sure that the city is affirmatively furthering fair housing. Now, this would be a requirement for those receiving federal funds. While not necessary to meet legal requirements, we encourage cities to create as part of their fair housing policy 2 items. First, the purpose and vision statement. This statement reflects why the city is creating a fair housing policy in the first place. It may reference the city's obligations under federal and state laws, or it may talk about how the city sees itself and how a fair housing policy is part of that vision. Whatever it is, this statement really is the why of the document. The Fair Housing Policy Statement is the statement by the city that it will follow the law, that it recognizes the following protected classes and having a list of the protected classes, and that the rest of the policy is really built on this statement. So it's the abstract for the rest of the policy, or the summary. When city residents need to find information about housing discrimination, the city is often the first place that it will go to seek information. This could be someone walking in the actual door of the city hall, or someone looking for referral services on the city's website. The city should be prepared to have adequate information readily available and should be able to point constituents in the right direction to have their issues addressed. A city can outline how it will provide this meaningful access in its fair housing policy. Cities that have rarely seen a fair housing complaint may be surprised by the number of such complaints in the metro area. From 2017 to 2014, the recently published Addendum to the Regional Analysis of Impediments to Fair Housing, which includes the 7-county metro region, reported that HUD received between 46 and 57 complaints each year, coming from 23 to 29 cities in the metro area. In the same period, MDHR, the Minnesota Department of Human Rights, received 185 complaints from the metro area. And local legal service agencies received approximately 650 reports of housing discrimination. And this is with the legal services only serving the very poorest populations. These numbers reflect those residents who knew who to call and where to go. The truth is, most of the cities in the metro region really don't have a clear process for handling calls of housing discrimination or referring community members to places where they can get help. Therefore, it's necessary for cities to have a process for complaint identification and referral. The best way for cities to make sure they are receiving and referring cases is to designate a fair housing officer at the city who has identified to all staff and is named in its fair housing policy. The fair housing officer will receive calls about potential fair housing issues, track the calls in a fair housing log, and provide referral or educational material to residents. This fair housing officer is not expected to be an expert on fair housing. They should, however, be trained on the basics of fair housing and have updated information on local referral sources as well as where to find educational material. The city should also have a publicized phone number and or an online portal where people can contact the city with fair housing questions. This number or portal should, of course, go to the designated fair housing officer. Those cities who are recipients of federal funds also have an obligation to provide meaningful access to limited English proficient, or LEP, community members. LEP community members are those who do not speak English as their first language. How a city plans to provide this access is outlined in a city's LEP plan, and we'll talk briefly about that in a moment. Those cities who aren't receiving federal funds don't have the same LEP obligations. However, if those cities do have large populations of LEP residents, they may avoid disparate impact claims by making sure that those LEP residents are able to access this fair housing information. The fair housing officer should be familiar with the enforcement agencies locally, as well as local legal service agencies that may provide fair housing legal assistance. The city should also have a clear expectation for how quickly calls or emails will be answered by the fair housing officer. And finally, the tracking of the referrals in a fair housing log is a way for cities to document their responses to fair housing complaints in a timely manner. The log doesn't need to and actually shouldn't contain identifying information of the caller, but should list the date of the call and when the call was either referred to or sent information. Cities should consider making other city policies available to the public so that they can understand how the city is meeting its obligations under other civil rights laws. Cities can list these policies they are making available in their fair housing plan, or their fair housing policy. Examples of civil rights policies a city may have include an Americans with Disabilities Act policy. This policy explains how a city will make its facilities and services available to people with disabilities. A reasonable accommodation policy. As part of the Americans with Disabilities Act, cities are required to make changes to policies and practices if necessary to allow qualified persons with disabilities access. Cities are encouraged to have this policy available for review. The Limited English Proficiency Plan, referenced earlier, lays out how a city will provide meaningful access for those people who are not fluent in speaking, reading, or writing English. And finally, if a city has a housing and redevelopment authority or provides housing, a link to the state of Minnesota's Olmstead Plan and a statement of how the city plans to follow that plan. The Olmstead Plan, named after a famous Supreme Court case, Olmstead v. LC, details steps the state government will take to remove barriers for persons with disabilities to access integrated housing, including better access to services, funding streams, and safe and affordable housing. Cities providing housing to persons with disabilities need to be following the state's directive to make sure that their policies comply. These policies, all four of them, are discussed more in the Fair Housing Policy Guide that we spoke about that's made available by the Metropolitan Council. Attached to that guide is an appendix that provides examples for large and small cities of all of these policies. Additional best practices a city should consider are: 1. Instituting a Fair Housing Commission. As of 2017, the Minnesota Department of Human Rights reported that there are approximately 40 local human rights or civil rights commissions in Minnesota. These commissions are primarily made up of volunteer community members that serve the city's city council and focus on human rights and fair housing issues. So examples of work that these commissions can do include forums addressing the need of immigrant communities, providing community mediation services, appointing Fair Housing Commission members to sit on standing city council committees, such as the Planning Commission, the Comprehensive Planning Committee, or the Community Development Committee, or initiating conversations with internal city departments, such as the police department, regarding limited English proficiency policies. Some cities locally and nationally have also passed fair housing ordinances. These fair housing ordinances add additional protected classes within the city limits. For example, a local regional city here in the Twin Cities added age to their local housing ordinance, which is not a protected class under the state or federal fair housing laws. Another city in the region more recently strengthened provisions for Section 8 voucher holders. This is a way that cities, if they see a need in their community, can tailor their own ordinances to meet that need. Fair housing considerations and issues arise in all departments in a city, from project planning to inspections to licensing. Having a citywide understanding of fair housing laws and their implications will help staff foresee potential conflicts or disparate effects early enough to handle them in an equitable way. Additionally, whether or not cities receive federal funding, implementing internal best practices is the first step towards affirmatively furthering fair housing within their city government. The first commitment cities are encouraged to make in their fair housing policy is a commitment to regular and comprehensive fair housing training for staff and elected officials. Cities should train on fair housing violation identification and referral, limited English proficiency obligations if it applies, working with victims of domestic violence, and reasonable accommodations for people with disabilities. While fair housing and civil rights laws affect all areas, really, of a city, the following city departments should have specific guidelines regarding fair housing training. Front desk and reception staff are often the first people to interact with community members with housing discrimination complaints and issues, and probably will see most of the questions from residents. Housing and Community Development Department, these staff are often involved in project development or operations and should be knowledgeable about community engagement strategies and zoning and land use decisions. Two areas where inspections could interact with fair housing laws, are direct contact with clients who may be victims of discrimination through a lack of repairs or harassment by their housing providers, and code enforcement. The front line in responding to domestic violence calls, calls for medical assistance, and other calls to multifamily complexes, police and fire typically should be well-versed in fair housing laws. Police typically lead efforts also to get landlords and housing providers to comply with crime-free ordinances, which sometimes can go too far and butt up against fair housing laws. Police officers should also understand the protections afforded by civil rights laws, including protections to people with mental health disabilities and domestic violence survivors. The decision makers, elected officials, need to understand how policies and practices that they vote for and the community development decisions that they make affect protected classes, integration, and community health. The correlations between public health and safe, stable housing is becoming clearer and clearer. Those who study community health impacts should also understand the interaction with housing, including disparities in health outcomes among people of color, families with children, and new immigrant populations, and the impact of programs and requirements like those involving lead paint. Major city projects, whether housing, transportation, or economic development, have huge impacts, both good and bad, on the surrounding community. While community planning and development departments look directly at needs for housing and possible barriers to meet those needs, HUD's analysis of Fair Housing Handbook points out, quote, "The fair housing perspective focuses as much on the causes of needs of groups of persons protected by the Fair Housing Act as it does on the needs themselves. Therefore, while the explanation of barriers to affordable housing may contain a good deal of relevant analysis of impediments, it may not go far or deep enough into factors that have made poor housing conditions more severe for certain groups. Accordingly, cities should commit in their fair housing policy to a clearly defined and consistent procedure for examining the fair housing impact of city projects, not just the impact on the affordable housing stock, though the two often overlap. In particular, cities should be using this procedure on any project that is receiving city assistance, financial or otherwise. It's important that cities be thinking about fair housing issues early in the process, or else they may find themselves scrambling in order to avoid problems. Questions cities should ask when project planning include: will the planned project increase or reduce the amount of affordable housing in the city? Will the project require displacement of residents? Will the project affect protected classes in a disparate way? And if so, is there a less discriminatory alternative? Has there been community engagement in this proposed development? Does the project increase or decrease racial and economic segregation? And does the project address goals or objectives in the city's comprehensive plan? Cities are encouraged to develop or adopt a checklist as a best practice that addresses common fair housing issues or considerations like these that arise during city planning process. Nationally and locally developed rubrics may be helpful. Excuse me. Shown on the left is the City of Seattle's Racial Equity Toolkit, and on the right is the Equitable Development Principles and Scorecard, which was developed locally. Both of these are available in the Metropolitan Council's Local Planning Handbook and TOD Guide. In order to truly understand the long-range impact on city decision-making, including zoning changes, approval of new projects, and the need for programs like rehabilitation loans, a city needs to have a regular and ongoing picture of the housing stock in its community. Therefore, cities are encouraged to include in their fair housing policy a commitment to conduct a regular housing inventory and analysis, looking at the affordability of both rental and owner-occupied housing and addressing the need for further development of affordable housing in their community. The housing study should look beyond the inventory, however, and include such data points as an examination of areas of concentrated poverty and an examination of areas of concentrated wealth, and renter-homeowner disparities based on racial and familial makeup. Again, the Metropolitan Council offers tools. An annual existing housing assessment is created for each of the jurisdictions, and this assessment can be a starting point for a more robust look at a city's current housing picture and its future needs. This housing analysis does not need to be as detailed as an analysis of impediments created by the FHEO. Instead, it should be enough information that the city can use it to assess whether projects or programs are affecting the supply of housing or any protected classes living in the housing. Cities are also encouraged to state in their fair housing policy that they commit to conducting an analysis of zoning codes, building codes, and occupancy standards, looking for disparate impact on protected classes. After an initial deep dive into these codes, cities should conduct a periodic reexamination, as well as have a process for examining any new proposals of changes or additions to the codes. The purpose of the analysis is to assess fair housing issues and identify significant contributing factors in order to formulate fair housing goals. It is to look at what policies, practices, and activities are underway and to consider how they may facilitate or hinder fair housing choice. In the Analysis of Fair Housing Assessment tool for local governments, the Department of Housing and Urban Development looks for cities to make sure land use and zoning laws do not create hurdles to fair housing. This includes looking specifically at what are the permitted project scales and density, what is the process for the provision of financial resources, is there any assistance with site selection, is there the possibility of reduction of unnecessary parking requirements, for example, are there fee reductions or waivers for affordable housing, is there a reduction of administrative delays, does the city permit manufactured housing, and does the city have inclusionary housing policies? Cities need to pay specific attention to the fair housing implications in crime-free ordinances, which sometimes result in actions taken against those in protected classes, such as people with disabilities or domestic violence survivors. This can occur even if the ordinance has exemptions written into it for these populations. Occupancy limits. While occupancy limits are generally allowed, issues may arise if the occupancy limits are too strict that they disparately affect families with children or other protected classes. Definitions of family. Many cities have a definition of family within their ordinance in order to regulate the number of unrelated people within housing. Again, these are generally allowed. However, when the definitions of family are too restrictive, they may put an undue burden on housing for people with disabilities, requiring them to take more steps or clear more hurdles in order for their group homes to be allowed. And finally, specifically spacing requirements for group homes. Cities need to make sure that their spacing limitations do not impose greater restrictions on housing for people with disabilities. The importance of community involvement in fair housing decisions cannot be overstated. Cities are encouraged to include in their fair housing policy a statement about how they will engage with the community in an ongoing way. For cities receiving federal funding, robust community engagement is a requirement when making planning and financing decisions, when creating the HUD-required consolidated plan, and when developing any analysis of impediments to fair housing. For cities not receiving federal funding, community engagement is a best practice that puts the community needs, experiences, and expertise at the core of city decision-making. A variety of tools can be used to establish ongoing and meaningful relationships with the communities cities serve. They could include public meetings, workshops, and office hours in the community and during times when the community is most able to access. Creating ongoing or project-based steering committees with community members and or public stakeholder groups. Specific appointment of community members to establish planning or decision-making committees. Plan updates, meeting reminders, and other key information posted on the city's website and distributed via email, and a number of other ways to assist in community engagement. Again, the Metropolitan Council has resources in their local planning handbook on community engagement. Finally, recipients of federal funds are required to affirmatively further fair housing. What this means is to assess the elements and factors that cause, increase, contribute to, maintain, or perpetuate segregation, racially or ethnically concentrated areas of poverty, significant disparities in access to opportunity, and disproportionate housing needs. Including a statement about affirmatively furthering fair housing in your fair housing policy is a best practice. What this means is that cities need to complete the required analysis of impediments to fair housing, consider the recommendations and outline clear action steps with timelines that state how the city will address the identified barriers. It also means that it has to use the information gleaned from the analysis of impediments to inform decisions and actions throughout the city, and it must stay abreast of changes, needs, and new hurdles faced by protected class populations. To quote HUD's Fair Housing Planning Guide, quote, Jurisdictions should have full knowledge of all of the activities that have recently been completed or are underway to affirmatively further fair housing. The chief executive and administrative staff know the strengths and weaknesses of activities that the state or entitlement jurisdiction has initiated or in some direct fashion supported. However, this knowledge should extend well beyond this arena to actions taken by housing industry members, private organizations and foundations, the public housing agency, neighborhood groups, regional organizations, and others to further fair housing objectives." End quote. Now I will turn it back over to Jonathan for further considerations.
So in addition to the recommendations for our local policy that Lael presented, we wanted to mention a few other efforts that might be effective adjuncts to your policy development. For example, a concerted marketing or other effort to increase acceptance of housing choice vouchers, formerly known as Section 8 vouchers, can be a very strong show of support for fair housing. You promote or conduct events around Fair Housing Month, which is April, or you might develop strategies to help overcome NIMBYism in the community. Additional things to consider include considering expedited review or other incentives for affordable projects in high opportunity locations, integrating mixed income housing into long-term plans or considering adoption of a mixed income or inclusionary housing policy, working fair housing considerations into programs, projects, and activities regardless of the presence of fund source mandated requirements, and requiring affirmative fair housing marketing plans for city approvals. HUD provides a template for such plans. Finally, you could consider showcasing your fair housing goals and efforts in the housing element of your comprehensive plan update. Determining the best policy for your community can surely be challenging, but asking a few key questions might help. For example, you might ask, what is our potential budget for fair housing related activities? Where within our organizational structure would fair housing planning be housed for best and maximum impact? Do we have the staff capacity to follow all of the recommended steps or just some of them? And if not, what activities should take priority? Similar to key questions you might ask, there are a few likely key steps to take in the development of a local policy. For example, you'll need to secure or seek assistance in developing buy-in. You'll want to ensure participation from elected officials and policymakers in addition to staff. You'll want to discuss the internal and external features desired most in your community and most likely to have maximum impact. You can use the model template to begin drafting your policy, and we encourage you to reach out if you need assistance. Just a word on participation in the Livable Communities Act programs. The Livable Communities Demonstration Account, the Local Housing Incentives Account, and the Tax-Based Revitalization Account already require that grant recipients for projects including housing create affirmative fair housing marketing plans. Consistent with the 2040 Housing Policy Plan, LCA grant recipients will soon be required to adopt a local fair housing policy, and we anticipate this requirement to be outlined in the 2018 Fund Distribution Plan. So we hope that between this webinar, the Fair Housing Report we're making available as a resource, and the Model Local Fair Housing Policy, we've demonstrated some reasonable and low-cost ways to strengthen your local fair housing offerings. The model policy in particular is meant to be a starting point to which things can be added or subtracted based on your capacity and objectives towards furthering fair housing, and that's really what we mean by the policy being scalable. And finally, we want to highlight that our staff stands ready to assist either directly or through our partners to help you craft a policy that is effective but sensitive to the local environment.
Perfect. Well, thank you. I just have a few things before we move on to questions. Here are a few of the links that were either mentioned or will be useful as you are working towards creating a fair housing policy for your community. Don't worry about writing them down. These slides will be available later. And then the local planning handbook in particular is a key resource for comprehensive plan updates, which were mentioned a few times for accessing resources. Okay, now we have time to answer a few questions. What are some tools to help normalize the need for affordable housing so that there is broad policy support for these legal requirements and best practices and procedures?
That's a really great question. I think that the best way to normalize or to start talking about it really is to look to who in your community you can collaborate with. What are local organizations, nonprofit organizations, social service organizations that are affordable housing experts, that work with people who need affordable housing, and have them come in and start providing information, providing education. The reality is, in our current world, you'd be surprised at how many people can qualify for affordable housing, and really, it's everybody that you know. I mean, it's the dry cleaner you take your dry cleaning to. It's your child's best friend. It's the teacher's aide at your daycare. It really is. The more you learn about who needs affordable housing, the more it does become normal. So look to organizations such as Community Action of Hennepin County, or to VIII, or to Legal Aid, or to Housing Justice Center to help you bring that information to your decision makers and to your city staff to start the conversation and to support you in these changes. There are also organizations that help with larger community support, including like Jewish Community Action, or MICA, which is the Metropolitan Interfaith Community on Affordable Housing, other agencies that focus on broader community support as well.
If a city does not have an HRA, do they still need a fair housing policy? And similarly, if the county serves as the HRA, is the city required to have a fair housing policy, or is the county HRA or CBA?
That's a good question. This fair housing policy that we're talking about really is directed towards cities as in their role as city government. So the fair housing policies we're talking about are for city departments like police departments, inspections, planning, urban planning. So it really is for any cities, regardless of whether you have an HRA. Now, cities that have a housing redevelopment authority or a community development authority that also have housing that they operate or that they own, they may have additional obligations under Fair Housing Act, under Minnesota Human Rights Act as housing providers. But this fair housing policy really is directed at cities that do or don't have an HRA. So I would say, yes, this is really for all cities, regardless of the HRA.
Is there some of the information for the housing inventory available through census or another agency?
Yes, actually, there is quite a bit of information available. So the first place that I would direct you to is to the Metropolitan Council itself. It has, as I briefly mentioned, I believe an existing housing assessment that it has for each community. It also has community pages for each of its jurisdictions that has a lot of information. There's also the American Community Survey, which is part of the census, that would provide a lot of information. And HUD has a fair housing tool and an assessment tool that was designed to assist with those who create analysis of impediments, but it is available to anybody, any city. So on their website, you could just look for an analysis of fair housing tool. You could do a Google for that, and that has a lot of information that covers the demographics we're talking about, like racial demographics and poverty demographics and familial status demographics.
This actually relates to the previous question that I asked with the HRA, whether a city has to have an HRA. This seems like it could take a lot of city resources. Are there grants available to implement the policies?
That's a great question. I don't know the answer to that. I'd like you to take a look at the fair housing policy, the model policy that we looked at. that we created, and it really is scalable to based on your resources. Now, there may be grants out there that I don't know about, but you may be able to get grants to do things like the housing analysis or the zoning and code analysis. But other things could be implemented that won't necessarily cost a lot. For example, identifying a fair housing officer, depending on the size of your staff, you may be able to do that very soon. You may be able to, your city may already have a policy regarding the ADA. And so just making sure that that's up on your website and is prominent, that may cost very little money. But maybe Jonathan and some of the Met Council and Metropolitan Council staff could look to see if there are other grants available to cities to do this sort of analysis.
Okay. Can we get an update on fair housing with regard to people with criminal backgrounds?
Sure. So that is always kind of a sticky area because people with criminal backgrounds are not a protected class under, excuse me, under federal or state civil rights laws. Now, that being said, if people have a criminal background and that criminal background was because of, let's say, some sort of disability, like a mental health disability that has now been addressed, people with criminal backgrounds may be able to access reasonable accommodation policies. Again, criminal backgrounds or the fact that someone has a criminal background is not a protected class under civil rights laws. But if that criminal behavior was related to a disability that the person has, and there have been, plans put in place to address the mental health issues or the disabilities, reasonable accommodations may come into play. So it really is a case-by-case basis when it comes to that. It's kind of a complicated answer but it's a complicated area. So.
Where's the place to access training on fair housing laws? Basically, who offers the training?
That's a great question. And actually, that is something that we see as an ongoing need. What I know is that from my time at Legal Aid, Minneapolis Legal Aid, I do know that legal assistance organizations around the state offer fair housing training. I do know that contacting HUD to see if they may have some training available. But we do recognize that as an ongoing need, an ongoing development of perhaps a training curriculum is something that we've kind of put a bug in the ear of the Metropolitan Council as far as that need. I mean, there is also organizations such as the Housing Justice Center that could potentially do fair housing training, and other organizations, maybe the other nonprofit agencies may offer training, but there's no particular agency or one-stop shop that provides the training right now.
There was a comment made about addressing fair housing when city assistance, finance, or otherwise is given. Mm-hmm. Do you feel that a rezoning or planning approval will qualify as that otherwise that was mentioned?
Yeah, there have been some cities currently that have created this their inclusionary housing policies where rezoning or the request for a PUD has triggered this requirement for affordable housing to be included in the development. Brooklyn Park just passed one. I believe that St. Louis Park, I think, also has some sort of a trigger that isn't financial assistance, but it is a rezoning or request for a PUD. So there are cities that are using that as the way to increase affordable housing development.
Okay, and this would be our last question. Unfortunately, we have more questions to answer, but for any question that we didn't get to, we will post the answers at the end. I still haven't asked the final question.
Okay, yes.
So if you can, if it's possible to provide a short answer, otherwise we can always provide longer answer in that Q&A document.
Okay.
What are the implications of not having a fair housing policy?
A fair housing policy as of this time is not legally required by any body. The Metropolitan Council will require the creation of a fair housing policy as part of their analysis to grant Livable Communities Act grants in the future. So that will be an implication. But as far as if you're not applying for LCA grants, there really is no legal obligation to create it. Now, there are other legal obligations that we said, such as making sure that you don't have disparate impact, that you don't have disparate treatment, and that you affirmatively further if you're receiving federal financial aid. But we see this more as a best practice and as a way that cities can put fair housing foremost in their city planning and city development.
Well, thank you, Jonathan and Leo. I just want to mention a few things before we say goodbye. First of all, if we didn't get to your question, we will post it through a Q&A document, which along with the presentation itself in a PDF format and the video recorded version of this webinar will be available on our website, and that will happen within the next week. So you will please check back on the PlanIt Metropolitan Council metrocouncil.org/PlanIt and go to the webinars page. The materials for this webinar will be there. And also, if you want to claim any AICP CM credits, this webinar has 1 credit, so make sure to log that in. And as you are exiting the webinar, there's a very short survey that we ask you to take if you can. We'd really appreciate it. With that, this was again our last webinar. Thank you so much for staying with us, and I hope that you have been able to get a lot out of all the webinars. Again, all the resources can be accessed through the PlanIt page of the Local Planning Handbook. Thank you.